Hi, I'm attorney Greg Dell here with attorney Stephen Jessup. And Steve, I want to talk to you about something that's probably one of the top 5 reasons that we see claim denials, and that has to do with the change in definition that comes about in a long-term disability policy, and that obviously has to do with a change from an own occupation definition usually to an any occupation definition, or used to be that you're able to do your own occupation, then you can't do a job that pays you more than 60% of what you used to make. But for the most part, they're usually it's from your own occupation to any gainful occupation, which is very similar to the Social Security disability standard. Very common in almost every group long-term disability policy, because all of these group disability carriers governed by ERISA make you apply for Social Security disability. So they kind of tie that in to say, look, after 12 months or 24 months of getting paid benefits, your definition is going to change. So we know that a big chunk of the calls we get every week are either I've been denied because they changed my definition, or they've notified me they're doing an evaluation of my claim and they're saying that I'm going to have this change of definition in 4 or 5 months. What can I do? So let's talk about first some things that possibly people could do to prepare for the change in definition to help avoid a denial.
I think really it starts from the beginning of the claim. The vast majority of people are going to have jobs that fall in a sedentary, light-duty capacity. So when an insurance company is reviewing, your ability to do your own occupation during the initial 24 months, at the end of the day, as much as they're supposed to look at the actual material and substantial duties, they usually try to just dumb it down to what those physical demands are of the job. So in setting up, say you do have a desk level job, you do sedentary work, from the get-go, you're not only trying to necessarily establish that you can't do your particular job, but you can't do anything else that will require the same physical abilities. A lot of people just kind of take it for granted when the claim's approved and think, oh, 2 years down the road, that's so far away. But the reviews that the insurance companies are doing start very soon on, and then within 6 to 8 months before the change, full blown is when they're really going to start looking at it. So some of the things you really need to be cognizant of, what the medical records are saying. We've seen a lot where the doctors don't necessarily document all the complaints that are happening, or there's a standardized software where you click the boxes and there's maybe a little blurb about what's going on. So if there's any, if there's contradictory evidence in those records because of a data entry problem compared to what's written, insurance companies will look at that. Or if the records aren't documenting much of anything, silence by acquiescence by silence. If it's not there, it's not happening, kind of thing. So first and foremost, the biggest for any claim, and then longevity of it, is going to be what is in those medical records.
And so, like you said, when I look at any claim, and we help people apply for benefits all the time, then we help them manage their claim, I really look at the change of definition as almost starting over again. And often they send it to a new claims adjuster, because that's like the way the claims people are trained is, okay, they got approved for this first thing, and then we're going to look at their medical records every couple months and see if they're still eligible. Oh, in my training as a claim rep, now I got this change of definition, I'm going to reevaluate the whole damn thing and see if I can come up with a reason to not pay the claim. And you were right, the first place is in the medical records. Well, so what we do is obviously we're regularly getting the medical records and we're reviewing them. We're also consulting and advising our clients as to how they should be communicating from a medical legal perspective with their doctor to make sure things are documented appropriately in the records. Because like you said, everything's automated. I think it's required now by law to have the digital files, and a lot of these things have software that go through range of motion, levels of pain, and then the dermatomes, do you have loss of sensation on a 1 through 5 scale? And often it starts off, not often, it does start off that everything's normal. So if you have a doctor who's not very detailed and leaves a person who's saying I got numbness in my fingers, numbness running down my arm, and I have weakness in my hands, but the doctor has 5 out of 5 for all the symptoms saying there's nothing wrong with you, and then where it says musculoskeletal area, do you have any discomfort in the neck, the back, the shoulders, and it says none, but yet you do, the insurance companies eat that up. And the doctor will get it back later after the fact and go, no, I know you told me about this and that. Sorry, it was my program that defaults to normal. So that's a big thing. It's very important to review the records. And often without representation, the doctors are hesitant to give the records to the claimants because they don't want the patients analyzing all of the records. But when they have a lawyer and they realize the importance of that, of somebody, guiding them and helping to avoid a denial, it's also less work for the doctor down the road. The other things, talk about, very often we see the company might change definitions coming and they want to come see me. What is that about, and what should a person be aware of? I know we've done a lot of videos on that, but in a nutshell, why are they doing that?
They want to put eyes on you. They want to see what you look like, how you're presenting, especially if it's a pain-related condition. The people that come out are trained to interview and investigate. If you're saying you have a bad back and you can't sit, but you sit for a 2-hour field interview without much signs of discomfort, these types of things will be noted. Depending on the insurance company, they may have already done video surveillance prior to coming to see you. And then they're going to see if you're going to basically contradict what they captured. So they can catch you looking like you're lying. And if you're lying about this, then their whole claim review is going to be within that guise that you're going to lie to them. Because most of the problems that you're going to have, especially in the pain-related conditions, are subjective in nature. So they're looking for ways to show that you're not being truthful more than anything. And really, it's just to put eyes on you to determine that level of veracity.
Right, and when we are representing clients, we participate in that conference, we prep the claimants for the conference, we limit the scope of that conference, we make sure that, that the claimant doesn't sit there and feel uncomfortable answering what they need to answer, and not answering what they shouldn't answer. Also, sometimes they hire these third-party outside companies who don't know anything about the claim, and they come there and ask you 100 things that they shouldn't be asking. The other thing we see before the change in definition is those extensive activities of daily living questionnaires. How important is it, the manner in which those forms are filled out?
Crucial, especially some companies, the ones that they'll send to the doctors at that point. When you look through the answers they provide to the doctor, they basically corner the doctor to write that you have some level of functional ability to work. They'll have boxes, this person can do this, sedentary, frequently, occasionally. They never give the option for the doctor to say, no, they can't do this on the form. They're specifically engineered to basically give a result that is a lot of times different than what the doctor actually believes. I mean, we speak to people, we read the denial letter. I had one just the other day, and I said to the client, I said, did your doctor really say this? She's like, I don't know. I can't believe he would say this because he was telling me X, Y, and Z. So they are really focused on extracting what piece of information they want to go into this idea of we had a reasonable basis to deny the claim, or to give their reviewing doctors a really nice, something they can just clamp onto to also try to steamroll denial. So those forms are very, very important because they're going to be looking to see if it's been consistent with what's been there. Also, you also sometimes get in weird situations where, a person's been out of work for a little while, so certain things should be improving, from the rest and stuff like that. So if the medical objective evidence isn't supporting a worsening of conditions, a worsening of problems, but the person's reporting much harder restrictions and inability to do things, that's also going to raise an eyebrow with the insurance company. So it's really a continuity of information that's required.
The other thing I find important is educating the doctor that they're going to get this random call from a nurse or a doctor to go ahead and discuss the claimant's claim. And that's kind of like behind the back of the claim. If the doctor gets cold called and doesn't know about it, so we often prep our clients to have that conversation with the doctor to say, look, you really shouldn't speak to this person, because a couple reasons. One, the doctor from the insurance company will often call, have a meeting, and write up whatever that doctor wants without sending a confirmation to the doctor. So if that does happen, we always advise our clients, make sure that if the doctor does speak to the insurance company, that there's a confirmation sent back to the doctor can comment on. What I see is sometimes there is this confirmation sent in. It's a random fax. It comes in and says, we spoke, this is what was said. Half the time it's not what was said. And if you don't reply in 24 hours, we'll assume that you agree with everything that's in here. And it's always written pro insurance company, meaning that the claimant basically doesn't have the restrictions and limitations that the claimant actually has. And those are, very commonly used. So we're always advocating when we're involved, don't let that conversation happen. Make the doctor from the insurance company send the questions in writing. Then the doctor can prepare answers which can be reviewed by the claimant to make sure they accurately reflect what's going on. So, that's another tool that's used by the insurance companies all the time to deny the claims. Another technique we see often by Sun Life, and some of the other companies are doing this, is, hey, your definition of disability is changing. We're going to offer you 6 months of benefits because we're probably going to cut you off anyhow. And if you take those 6 months, then your policy's over, and they try to scare you into accepting a settlement. Have you ever encouraged anyone to take one of those?
No. Unless the person is planning on trying to do something or going back, or there's some life situation, no, they're just selling themselves short. I've seen people who've signed it, and then I've been contacted, and Sun Life's the biggest one, it's a strong arm buyout, and then they want to withdraw it, but they've already signed off on it, accepted the money, and there's really nothing that can be done at that point. So a lot of times people will call like, hey, I got a buyout offer from Sun Life, and my first question is, how long have you been on claim? And if it's been under 2 years, I know that's probably what they're looking to do, is to deny them after. So like, all right, we'll pay the remainder now, give you a couple months, and let you go on your merry way.
Right, and some of the other things that we'll do to prepare is we'll do additional testing. If it's a psych thing, we might do updated neuropsychological testing. We may encourage a doctor to send a claimant for a functional capacity exam, because we know they're going to do that. So we need to do it before they do it so that we have the better objective data, the more current data as to what's going on at the time of the change in definition, because we know all the tools that they're going to use to try cut off a benefit, and that becomes a problem. So you really need to be aware of all of these things that can go on at the change of definition. And often it's not just before, it might be a couple months after.
Yeah.
And the video surveillance you touched on before is absolutely gigantic at that change.
Very much so.
And they're going to try to get you on video for a couple days, or I've seen them go for a month here, a month there. They come back a couple days at a time. And if they're sending you for an IME exam at that time, we didn't talk about that. That's very common that they'll want to hire an outside doctor. They call them IMEs, which stands for independent medical exam. We call them compulsory medical exams because you have to go to them and there's nothing independent about them. So we have other videos about how to prepare for that. And if you are dealing with all of these situations between having to do new paperwork, possibly being interviewed, having to deal with video surveillance, having to be sent to compulsory medical exam, having to deal with your doctor who may be challenging and not supporting the claim or understanding what it means to have this change of definition. These are all things that we're here to help you with and that we deal with on a daily basis. We encourage you to call us. We're always going to offer you a free consultation. Any of the lawyers here at our firm are available to help you anywhere in the country, and we look forward to the opportunity to speak with you.